The answer is no. Marital rights, including the coverture and living in conjugal dwelling, may not be enforced by the extraordinary writ of habeas corpus. A writ of habeas corpus extends to all cases of illegal confinement and detention, or by which the rightful custody of a person is withheld from the one entitled thereto. Habeas corpus is a writ directed to the person detaining another, commanding him to produce the body of the prisoner at a designated time and place, with the day and the cause of capture and detention, to do, submit to, and receive whatsoever the court of or judge awarding the writ shall consider in that behalf. It is a high prerogative, common law writ of ancient origin, the great object of which is the liberation of those who may be imprisoned without sufficient cause. It is issued when one is deprived of liberty or is wrongfully prevented from exercising legal custody over another person. The petition of Erlinda K. Illusorio is to reverse the decision of the Court of Appeals in its resolution dismissing the application for habeas corpus to have the custody over her husband, lawyer Potenciano Illusorio, and enforced consortium as the wife. On the other hand, the petition of Potenciano Illusorio is to annul that portion of the decision of the Court of Appeals for giving Erlinda K. Illusorio visitation rights to her husband and to enjoin Erlinda and the Court of Appeals from enforcing the visitation rights. The undisputed facts are as follows. Erlinda Calao Illusorio is the wife of lawyer Potenciano Illusorio. Potenciano Illusorio is about 86 years of age, possessed of an extensive property valued at millions of pesos. For many years, lawyer Potenciano Illusorio was chairman of the board and president of Baguio Country Club. On July 11, 1942, Erlinda Calao and Potenciano Illusorio contracted matrimony and lived together for a period of 30 years. In 1972, they separated from bed and board for undisclosed reasons. Potenciano lived at Ordoneta Condominium Ayala Avenue, Makati City when he was in Manila, and at Illusorio Penthouse Baguio Country Club when he was in Baguio City. On the other hand, Erlinda lived in Antipolo City. Out of their marriage, they had 6 children, namely Ramon Illusorio, 55 years of age, Erlinda Illusorio Bildner, 52 years of age, Maximo, 50 years of age, and Sylvia, 49 years of age, Marietta, 48 years of age, and Shirin, 39 years of age. On December 30, 1997, upon Potenciano's arrival from the United States, he stayed with Erlinda for about 5 months in Antipolo City. The children, Sylvia and Erlinda, alleged that during this time, their mother gave Potenciano an overdose of 200 milligrams instead of 100 milligrams Zoloft, an antidepressant drug prescribed by his doctor in New York, USA. As a consequence, Potenciano's health deteriorated. On February 25, 1998, Erlinda filed with the Regional Trial Court, Antipolo City a petition for guardianship over the person and property of Potenciano Illusorio due to the latter's advanced age, frail health, poor eyesight, and impaired judgment. On May 31, 1998, after attending a corporate meeting in Baguio City, Potenciano Illusorio did not return to Antipolo City and instead lived in Cleveland Condominium, Makati. On March 11, 1999, Erlinda filed with the Court of Appeals a petition for habeas corpus to have the custody of lawyer Potenciano Illusorio. She alleged that respondents refused petitioner's demands to see and visit her husband and prohibited Potenciano from returning to Antipolo City. After due hearing on April 5, 1999, the Court of Appeals rendered decision, the dispositive portion of which reads, whereof, in the light of the foregoing discussions, judgment is hereby rendered. Number 1. Ordering for humanitarian consideration and upon petitioner's manifestation, respondents Erlinda K. Illusorio, Bildner, and Sylvia Illusorio Yap, the administrator of Cleveland Condominium or anywhere in its place, his guards and Potenciano Illusorio staff, especially Miss Aurora Montemayor, to allow visitation rights to Potenciano Illusorio's wife, Erlinda Illusorio, and all her children, notwithstanding any list limiting the visitors thereof, under penalty of contempt in case of violation of refusal thereof. Second, ordering that the writ of habeas corpus previously issued be recalled and the herein petition for habeas corpus be denied due course. as it is hereby dismissed for lack of unlawful restraint or detention of the subject of the petition. So ordered, hence the two petitions which were consolidated and here jointly decided. As thereof stated, a writ of habeas corpus extends to all cases of illegal confinement or detention, or by which the rightful custody of a person is withheld from one entitled thereto. It is available where a person continues to be unlawfully denied of one or more of his constitutional freedoms, where there is denial of due process, where the restraints are not merely involuntary but are necessary, and where a deprivation of freedom originally valid has later become arbitrary. It is devised as a speedy and effectual remedy to relieve persons from unlawful restraint as the best and only sufficient defense of personal freedom. The essential object and the purpose of the writ of habeas corpus is to inquire into all manner of involuntary restraint and to relieve a person therefrom if such restraint is illegal. To justify the grant of the petition, the restraint of liberty must be in illegal and an involuntary deprivation of freedom of action. The illegal restraint of liberty must be actual and effective, not merely nominal or moral. The evidence shows that there was no actual and effective detention or deprivation of lawyer Potenciano Ilurio's liberty that would justify the issuance of the writ. The fact that lawyers Potenciano Ilusorio is about 86 years of age or under medication does not necessarily render him mentally incapacitated. Soundness of mind does not hinge on age or medical condition, but on the capacity of the individual to discern his actions. After due hearing, the Court of Appeals concluded that there was no lawful restraint on his liberty. The Court of Appeals also observed that lawyer Potenciano Ilusorio did not request the administrator of the Cleveland condominium to not allow his wife and other children from seeing or visiting him. He made it clear that he did not object to seeing them. As to lawyer Potenciano Ilusorio's mental state, the Court of Appeals observed that he was of sound and alert mind, having answered all the relevant questions to the satisfaction of the court. Being sound of mind, he is thus possessed with the capacity to make choices. In this case, the crucial choices revolve on his residence and the people he opts to see or live with. The choices he made may not appeal to some of his family members, but these are choices which exclusively belong to Potenciano. He made it clear before the Court of Appeals that he was not prevented from leaving his house or seeing people. With that declaration and absent any true restraint on his liberty, we have no reason to reverse the findings of the Court of Appeals. With his full mental capacity, coupled with the right of choice, Potenciano's Ilusorio may not be subject of visitation rights against his free choice. Otherwise, we will deprive him of his privacy. Needless to say, this will run against his fundamental constitutional rights. The Court of Appeals exceeded its authority when it awarded visitation rights in a petition for habeas corpus when Erlinda never even prayed for such right. The ruling is not consistent with the finding of subject sanity. When the court ordered the grant of visitation rights, it is also emphasized that the same shall be enforced under the penalty of contempt in case of violation or refusal to comply. Such assertion of raw, naked power is unnecessary. The Court of Appeals missed the fact that the case did not involve the right of a parent to visit a minor child, but the right of a wife to visit a husband. In case the husband refuses to see his wife for private reasons, he is at liberty to do so without threat of any penalty attached to the exercise of the right. No court is empowered as a judicial authority to compel a husband to live with the wife. Coverture cannot be enforced by compulsion of a writ of habeas corpus carried out by sheriffs or by any other messy process. That is a matter beyond judicial authority. It is best left to the man and woman's free choice. Wherefore, in General Register number 139789, the court dismisses the petition for lack of merit. In General Register number 139808, the court grants the petition and nullifies the decision of the Court of Appeals insofar as it gives visitation rights to respondent Erlinda K. Ilusorio.